Welcome to an oral argument session of the 5th District Court of Appeal. I'm Jay Cohen from Judge out of Orange County. We've got Brian Lambert out of Marion County, and we are very honored to have with us this morning Judge Siegel, Robert Siegel from Brevard County, sitting with us as an associate judge today. And so we're going to make him do all the work this morning. We are on Zoom. I understand, I could be wrong about this, wildly popular on Zoom. Our hits are going off the chart. So if you have, animals or children that would like to be involved and like to see themselves, on Zoom, invite them in. I think we're all good with that. We've got a number of cases over the course of this morning. We are doing them individually over Zoom. So to announce the first case, that will be Paul Knapp versus State of Florida. That's case number 193543. Mr. Pinnell, you may proceed when ready. And as you know, I have a 5-minute default on rebuttal. If you'd like something different, just let me know. We'll be glad to adjust that appropriately.
Sounds good, Judge. Good morning. May it please the court. My name is William Pinnell, and I represent the appellant Paul Knapp in this case, and I'll reserve the 5 minutes for my rebuttal. In this case, the trial court erred in denying claim 1 of Mr. Knapp's Rule 3850 motion following an evidentiary hearing. The evidence at that hearing established that his trial attorney provided him with ineffective assistance of counsel by failing to raise the appropriate objection to the trial judge requiring him to choose between the arguments of lack of intent and subjective entrapment. And Mr. Knapp was prejudiced as a result because he was not permitted to argue, present testimony, or get an instruction on subjective entrapment.
You would have to show what in terms of prejudice on this? What is your burden?
The prejudice burden is under Strickland is to show that there's not confidence in the outcome, and it says in Strickland they explicitly said in order to establish prejudice, the defendant need not show that counsel's deficient conduct more likely than not altered the outcome. You just have to show a reasonable probability. So it's not even by a preponderance. It's just some level of did the error raise a question about the reliability of the verdict, and that was Mr. Strickland was quoted by this court in Romero, where this court said the U.S. Supreme Court has held that prejudice exists if counsel's performance was deficient enough to undermine confidence in the outcome, even if it cannot be shown by a preponderance of the evidence to have determined the outcome. So
it seemed factually in the case that you had this cat and mouse going on with your client and the police officers, but it seemed that there was a fair amount of evidence to support this conviction, and I'm not sure that how you even get to the point of establishing that there was even a possibility that the outcome would have been different.
Okay, well, let's start with there's a fair amount of evidence. This court in Romero found prejudice from a deficient performance, even where there was, quote, ample evidence to support the defendant's conviction. So I don't think the amount of the evidence is dispositive, and I would respectfully disagree that there was ample evidence of guilt here. But that being said, the trial court's decision to limit Mr. Knapp and trial counsel's failure to raise the appropriate objection deprived Mr. Knapp of a viable defense in this case because there was significant evidence of inducement on part of law enforcement.
What is
trial
that?
Court.
What's the significant evidence of inducement as opposed to if you just set the table? I think there's case law that says that's not enough for that to be inducement. There has to be more of an arm twisting or coaxing or whatever the term is used. So how do we get to that level as opposed to the officers just set the table and you guys took the bait?
Sure. I would suggest that this case is similar to this court's decisions in Euler and Morgan, where they found there was evidence of inducement and said it was error not to give the instruction. But here we even have more evidence of inducement or encouragement. The trial judge in this case didn't acknowledge that under the statute you can show inducement through inducement or encouragement.
Yeah, Mr. Pennell, they offered to walk away on this.
More than
And
one.
your client, declined that invitation to walk away. I mean, the police officers offered to walk away from this whole thing, and yet he didn't do that.
Sure, but again, that's one way to view the evidence. The other way is, and the things I think the trial court ignored in reaching its decision that there was no inducement, that this Craigslist advertisement, the original advertisement included no indication that any minor child was involved. It just talked about.
They never do, and they couldn't. I mean, Craigslist, none of these, tools that are used by law enforcement are going to directly allow someone to say, sign up for illicit sex with underage minors, and allow that advertisement to get placed. So that argument doesn't seem terribly persuasive.
Well, I hear you, but also we know from the testimony, it's undisputed that this casual encounter section on Craigslist requires the users to affirmatively indicate that they're 18 years of age or older. And I hear your skepticism, but this court in Euler and Morgan pointed to those facts as evidence of inducement. So, and practically, because the police can't do it, doesn't mean that they're not injecting ambiguity into the situation because of those practical limitations. So they're making representations that suggest that there's adults involved here, whether that's because of the practical limitations or not. They are actually making those representations. And
right, then they begin the conversation and they disclose early on that we're talking about an underage minor. And at that point, your client had the opportunity just to say, well, I'm not interested in that.
well, that's what this court said in Morgan, that most people would walk away, but that doesn't make it a lack of inducement. But I think the more important evidence in this case is when Mr. Knapp was expressing uncertainty and some reluctance to be involved, he asked for a photo to clarify the identity of these people, and he sent a photo of Detective Marzian, who was actually 27 years old, not 13 at the time. So, and Mr. Knapp testified specifically that he only traveled because he received a picture of a 27-year-old Detective Marzian and a picture of Detective Pruitt, who was posing as a 26-year-old. So we have evidence that he was provided 2 photos of adult women during these conversations. So you're correct that there's this indication that there's a 13-year-old in writing, but then there's this contrary indication, encouraging, instigating, persuading Mr. Knapp to travel by sending photos of adult women. If his intent is to travel to engage in lawful sexual conduct, there's nothing inappropriate about that, and that convinces him to continue to engage in the communication and to travel to the undercover location. So, and then finally, during the communication in question, when one of the detectives was posing as the imaginary 13-year-old Ginny, she asks Mr. Knapp, "What would you like to teach Jody?" Suggesting that Jody, the adult, would be involved in sexual activity. So now we have photographs of 2 adults, and we have the imaginary 13-year-old suggesting to Mr. Knapp that the 26-year-old is going to be involved in sexual activity. If that's not encouragement to someone who admittedly logged on to the casual encounters section of Craigslist to look for a sexual experience with an adult, if pictures of adults and statements suggesting that an adult is interested in legal sexual activity isn't an inducement or encouragement for him to travel, I don't know what would be. Sir, he was looking.
How does that jive with the language inducement can be found only when the government has ventured beyond a simple offer, say by pleading with a defendant. That's out of Singer, and I wrote that. Actually, I quoted that from somebody else, but I wrote it. So, I mean, so in the context of what we have here, the inducement had to be, for it to be past the first step under the subjective entrapment, there has to be inducement. There has to be some kind of pleading, not pleading like I'm pleading a cause of action, but I'm pleading for you to kind of go forward. You know, I'm really kind of twisting your arm, and I'm trying to understand where we get to that here based on the facts of this case, so that somehow, you know, we have some doubt in the reliability of the verdict that was found by the jury.
Sure, Your Honor. I respectfully disagree that there has to be pleading. I mean, if you look at the standard instruction or the statute, it talks about inducement being defined as persuasion, fraudulent representations, threats, coercive tactics, and then it also defines encouraged as, and this is from the Jeanette case and the instruction, to instigate, to incite the action, to embolden. And I would suggest if you look at the Morgan and Euler cases from this court, there's no pleading in those cases. So I think the language from Sanger or that particular part of the decision is suggesting that's one way you can get inducement, not the only way. We know from the statute and the other cases, including Jeanette, Euler, and Morgan, that encouragement or inducement is sufficient, and encouragement is just attempt to persuade. When you have Mr. Napier, who's not sure he's going to travel, not sure what he's going to do, then you're sending adult photos of adult women when this person was originally logged onto an account looking for a sexual encounter with an adult. I think it's fair to conclude that the jury could conclude that that was encouraging him to communicate and encouraging him to travel. And we have evidence of inducement and encouragement.
But wouldn't they have just been inducing him or encouraging him to go have sexual activity with an adult? I mean, that wouldn't constitute a crime.
But that's not the issue. The issue under entrapment is whether you induce the actions of the defendant. Because under the reason we're here is under
Engaged in conduct constitutes
get guilt to the elements. You just have to admit the conduct. So Mr. Knapp does not dispute that he communicated with these individuals, that he traveled to the undercover location. He wished to make two separate arguments. One, that the state failed to prove that he had intent to engage in sexual activity with a minor. And two, that his conduct by traveling and communicating with these individuals was induced by the conduct of law enforcement. And we know from Wilson and we know from this court's previous decision in Knapp, which was written by Judge Lambert, that those are not
For everything here.
I'm sorry?
I'm causing all the problems here today, aren't I?
Yes. So we know that those are not internally inconsistent, and the trial judge in this case found that they were not internally inconsistent in this case. And I suggest the evidence shows that they're not inconsistent. In fact, they're both viable defenses. So I would disagree with the court's skepticism that there's not sufficient evidence of inducement in this case, and the trial court's conclusion on that fact. Because if you compare the facts of this case to the facts of Euler and the facts of Morgan, there's actually more evidence of inducement and encouragement. And in both those cases, this court found that there was sufficient evidence to warrant the instruction on entrapment, and it was reversible error not to give it.
Do you think your client's separate defense of basically I had no intent to do it, I was just kind of doing some undercover work on my own here to try to root out this problem, and I was going to turn this over to whoever the authorities are, that negates your argument that there's some prejudice here? Because I mean that's a separate defense. I understand you can have mutually exclusive defenses, but that being said, you're saying I've now been prejudiced because I've not been able to present this entrapment defense, when right out of his mouth at the time was I had no intent of doing this. I was going to go and investigate this and turn this over to the authorities. So isn't that a factor in the judge's analysis under the prejudice prong in Strickland that is problematic for you here?
I don't think so, Your Honor, and here's why. I think they both things can be true. I think he could be going to investigate it. If there's a child, he could report it to law enforcement. And then he testifies if there was an attractive adult woman there, he may have pursued a sexual encounter. So I think both those things can be true. And I point to this court to the Platt decision from the 4th DCA, which refutes this conclusion that if you had the ability to raise one argument, legitimate argument, then you're not prejudiced. In Platt, they said there was a facially sufficient claim of ineffective assistance of counsel where the trial attorney didn't ask for the instruction on excusable homicide, even though there was also the trial counsel pursued a separate defense of self-defense. So they still said it could be ineffective if there are two viable arguments or two viable defenses. The same conclusion was reached by the 1st DCA in the Mathis decision, where they reversed an aggravated battery conviction. And the court specifically pointed out, and this is in the same procedural posture as we're in, there were a reversal of a conviction following a 3850 hearing, and the court noted that the counsel raised two alternative arguments in appellant's defense. One, that there was only a fist fight and not the intent necessary for aggravated battery, and two, self-defense. So, but they found that trial counsel was ineffective for not asking for the instruction on justifiable use of non-deadly force. So again, in that case, there's two viable arguments, and they still found that there was ineffective assistance of counsel. So it's our position we have the same situation here. We have a viable argument that the state failed to prove intent, and a viable argument that there was subjective entrapment. And without the trial judge cut the defendant off at the knees during jury selection and completely deprived him of providing testimony, getting the instruction, or making argument in closing on the issue of subjective entrapment.
Well, but they asked what other witnesses he would have called, and he said there were no other witnesses that he was going to call.
That's correct, Your Honor, but Mr. Knapp testified at the evidentiary hearing about additional testimony he would have provided at trial that he did not provide at trial because he wasn't asked questions about entrapment. And trial counsel, Mr. Schwartz, testified he didn't ask the questions about entrapment because he was precluded from, and he didn't cross-examine the officer, and he didn't make arguments, and was unable to use the instruction because he didn't get it. So there was a substantial difference in how the trial would have looked had the trial judge not limited the defense in this case. And I'll reserve the rest of my time for rebuttal.
All right, thank you, sir. All right, Ms. Davenport. If you would address some of the case law that Mr. Pennell has cited, we have a good grasp, I think, on the facts of the case.
Okay. First, he talks a lot about Morgan and Euler, which were direct appeals where there was no entrapment instruction given. I think they well illustrate the difference between an entrapment case and a case like we have here. In Morgan, this court noted that the defendant never agreed to having sex with the daughter. He focused on the mother, and he repeatedly expressed reservations about the daughter. We don't have any reservations here. The only reservations the defendant had here was using language that could get him arrested. He was very careful to talk in code and to not say any inappropriate words referring to the younger one, but he never said, gee, I'm not interested in her. He made it very clear he was interested in her, but he wanted to be careful as to how he expressed that interest so that he wouldn't get arrested, which, in my opinion, shows that he was predisposed to do this. He knew it was criminal. He took a lot of steps that just an average Joe looking for an adult would not have known to take. Euler was the same thing. In that case, when they sent the picture, the defendant expressed disbelief that the purported child was so young. He also, the court noted, only reluctantly committed to see what happens when they met. He never said, we're going to go back to your place. He was very reluctant, and he didn't believe the child was really a child. When you look at the defendant's reactions to the pictures here, he never said, oh my gosh, you look so old, or I don't think you're really a kid. He said, wow, you're really pretty. He never brought that up until the 3850, when he was interviewed, when he was arrested, he never said, I thought I was meeting an adult. He said, I came to save this child. I was going to call DCF as if this was real. When he-
We'll start it. I guess we could start with a certain premise, and that is that the judge was legally wrong in denying the instruction on entrapment. Would you agree with that?
This isn't an instruction case. This is he wouldn't let him present evidence case. So they didn't ask for an instruction on entrapment because right up at the beginning, according to what the trial court found here, they were told they had to choose. And they chose.
Well, okay. So the judge tells him, you got one or the other. I mean,
Right.
that's effectively not precluded him from the defense of entrapment. Would you agree that as a matter of law, the judge erred in that decision?
Yes, I would agree with that.
Okay, so then the only issue then is prejudice prong of Strickland.
Correct.
Okay.
And to show prejudice, he needs to show that the outcome of the proceeding, there's a reasonable probability that would have been different. We lack confidence in the verdict. And when you look at the evidence he presented and in support of entrapment, there's really nothing here. It's much more in line with the cases where this court has found that there was no entrapment. Singer and Muriel. When you look at those cases, there's really nothing here. What he said to the police was, I didn't have intent. I was rescuing this child. What he said in his trial testimony, same thing. And what he said during the conversation with the kid was, I'm really interested in you. He never said, gee, you seem a little old or anything. He never expressed any skepticism that this was really a child. And that's
the distinction that you raised with Euler and some of the other cases that Mr. Pinnell cited. Why would it make a difference whether factually the analysis was on direct appeal or in terms of what constitutes entrapment, or whether it's on post-conviction?
Because in those cases, they presented evidence of entrapment and didn't get the instruction. And it's really, really easy to get an instruction. I mean, a scintilla of evidence entitles you to an instruction on your defense. Versus here, we're in the post-conviction context where he has the burden of showing a reasonable probability that the outcome would have been different. It's a completely different standard. So that's, another distinguishing feature. But again, the facts in those cases, I think, illustrate a situation where, entrapment's kind of a hard sell, but certainly possible in those cases because they did have to cajole the defendants to a certain amount because they didn't believe it was a child. And they expressed reluctance about having sex with a child. This guy was completely different. He sold himself. He made it clear that this was going to be all about the kid. He was experienced. He had a long, slender penis, so he wasn't going to hurt her. He asked, if she was allergic to latex to make sure that he could bring the correct condoms. I mean, he did the classic, I'm here to help you. I'll be your teacher. I'm experienced and kind, and this will be all about her, and she'll have a fantastic time. Versus in these other cases, there was some reluctance there, and they showed more interest in the adult. Just to clarify a part of the record, since counsel brought it up here in oral argument, and it's in his brief. If you look at page 373 of the record, there's an email there that the defense asserts shows that Jody, the older sister, was offering herself as a sexual partner. That's not supported by the record. That was an email. Jody, the older sister, says, I'm 26. It's not about me. It has to be about Ginny, the younger sister. The defendant says, show me a picture of her, no nudes. Jody responds from the same email address and says, this is Jenny. Tell me what you can teach her. This is Jenny's picture, not I'm Jenny talking now. Are you going to teach my 26-year-old sister how to have sex? It's complete. I mean, when you read that in the context of the conversation, the older sister never offered herself as a potential sexual partner. It was always all about the child. She made that crystal clear. And again, as this court noted, towards the end, they repeatedly said, I think we need to call this off. You don't really seem to be interested in her. She's scared that you don't really want to have sex with her, and because the defendant was being so cautious about what he was going to say. So I think factually and legally, this case is much more in line with the cases where this court has found that there was an entrapment. And I would submit it's pretty similar to the Jackson case that I cited in my brief, where this court actually reversed a finding of prejudice because the alleged offense was completely inconsistent with the defendant's admissions and with his actions at the time. When you look at what the defendant said at the time to the child and to the sister, and when you look at what he said at the time when he was interviewed by the police officers, an entrapment defense was completely inconsistent with what he was doing at the time. And I would also note that during defense counsel's closing argument at the trial itself, he pretty much echoed the defendant's testimony. He was trying to rescue her. His ex-girlfriend had been assaulted as a child.
Well,
and he
at that point in time, the judge put him in the position where that's all he could argue, because the judge told him, you got one or the other.
Right,
So
but
I don't know that is of great help one way or the other.
I agree with that, but Your Honor, but what I'm getting to is the defense counsel also said the defendant has maintained this story throughout. This is what he said when he was interviewed. He's always been consistent. He couldn't have made that argument if he was arguing entrapment too, if all of a sudden he came up with this new theory that, oh, he thought it was an adult in those pictures, even though he never had that piece.
I don't know. He could have. Yeah, I could see making.
He can make that argument, but again, is there a reasonable probability that that would have been a successful argument in light of his actions at the time during the conversation with the purported child, and in light of what he said when he was arrested? He never mentioned either one of those things. So we would submit that's another factor to show this defense just had no chance. Absolutely.
Yeah, and I know this is really an aside, but I confess that I didn't go back and look at the direct appeal in this case. Well, did the state cross appeal the downward departure?
We did not, no.
Okay, I was just curious. Okay.
If the court has no other questions, we would submit that the prejudice prong was not shown here, and the trial court certainly ruled correctly in finding that there was no prejudice. The defendant's not entitled to a new trial.
Any other
Yes.
questions, court?
Thank you.
All right. Thank you, Mr. Davenport. Mr. Pennell, you've got a little over 346 is what you got. No, can't hear you. You got to unmute. There you go. That's easier.
Indeed, the court. Initially, I disagree with the state's interpretation of the record that there was no reluctance or equivocation by Mr. Knapp like there was by the defendant in Euler and in Morgan. We have the testimony of Detective Marzian herself on pages 117 and 118 of the trial transcript, where she says that Knapp was reluctant to go to the undercover house and did not discuss any specific sex acts during the communications. So the idea that he was ready and willing to go is just refuted by the record. It's similar to Euler and Morgan, and then you add the photos of the two adult detectives. The first photo was a 13-year-old detective when the detective was 13-year-old, but the two subsequent photos interjected ambiguity and encouraged Mr. Knapp to travel because there are two adult photos. So I believe this case is similar to Euler and Morgan, and the court is correct that there's no difference in the analysis because it's direct appeal or Rule 3850 context. As I indicated earlier, the reasonable probability standard is a relatively low burden on prejudice. I think that gets misstated at times and misunderstood, but right out of Strickland and cited by this court in Romero, it doesn't even have to be shown by preponderance. And I disagree, and I think if you look at pages 639 through 645 of the record, there's new evidence presented here at the evidentiary hearing as to what Mr. Knapp would have testified to had he been able to testify relevant to entrapment. He talked about the fact that he had no prior subsequent arrests, that he was not looking for a 13-year-old, that he was on the casual encounter site looking for a sexual encounter with an adult, that he receives photos of adults. He specifically testifies he would not have traveled without the photos being received and sent. So there's significant new evidence from Mr. Knapp that was not presented at the trial that raises to the level of a reasonable probability or calls into question the reliability of the verdict. And it went further than that. He testified specifically why that testimony wasn't offered at the original trial. He says he wasn't permitted to give that testimony because it was only relevant to entrapment. That's page 647 of the record. He only answered the questions his attorney asked him, which of course his attorney is following the judge's instructions and not asking inappropriate or what the original judge deemed irrelevant. And he testified, had he been able to raise this defense, he would have testified that he was investigating to see if a minor was involved, that he would have reported to the police. But if it was an attractive adult, he would have considered it a sexual encounter, which is consistent with his original intent that night by logging into the Casual Encounters website. And that's pages 647 and 656 of the record on appeal. We have Gary Swartz's testimony about what he would have done differently had he been permitted to argue entrapment. This is quoted by the trial judge on page 472 of the record. He gives detailed reasons why he would have acted differently and what he would have done differently had he been given the proper opportunity to do so. Finally, the state's reliance on Jackson is misplaced. Judge Cohen, you wrote that opinion and you found that the offenses were inconsistent because Mr. Jackson raised self-defense, but also chose to rob the cab driver. And you found that to be inconsistent. Why would he rob the cab driver if he was just defending himself? I would suggest in this case, there's nothing inconsistent about arguing lack of intent, the state failed to prove intent, and arguing that your actions, not your criminal conduct, your actions were the result of inducement and encouragement by law enforcement.
Mr. Pennell, whose opinion did you think was better written, mine or Judge Lambert's?
Well, I was a fan of Judge Lambert's opinion in this case, and a fan of.
Yeah, he's only here because I reversed the summary disposition.
Exactly. So I was a big fan of that decision. So for that reason, I picked Judge Lambert's.
Okay, all right.
I'd asked to reverse for the reasons stated in the briefs and stated today.
All right. Well, listen, thank you both. As always, you both do an exceptional job, both in the briefing and in the argument of these cases. And we'll be in recess at this time.
Thank you. Have a good day.
Okay.